misdemeanor offenses. You have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. If you have a right, you have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Courtroom 2, who do we have, please?
Position number 24, Mr.
24, okay.
Who's that? Position 24. He's not.
All right, this is conflict. Is Miss McLeod, or who is our conflict counsel on Zoom?
I didn't have this one as a conflict.
Is this Michael Tuggle?
No, you're on position 24 or 23.
I heard 24. Are we on 23?
24 is a conflict.
This is 24, Mr. Tuggle up here on our cell phone.
Oh, at the cell phone. Okay. Is our conflict counsel on Zoom?
No, she isn't, Judge. I tried to reach her, but when I spoke with her on yesterday, she did say she had something at 9, but I'll let her know she still has a
Okay. If you
conflict with us for this morning, and she knows she has something at 11 with us as well.
If you communicate with her, let her know if let us know. Ask her if she wants this case reset.
Okay.
All right. Thank you.
Okay.
Jail court. I don't have Miss McLeod present. That's his attorney. If you'll give us a few moments, as soon as we get a report, we'll let you know.
Good morning, Judge Law. This is going to be on the probation calendar for position 3, Mr. McCoy.
Okay. This is a probation revocation matter. This is State versus Anthony McCoy, case number 16 CR 014169B. And typically they also have, okay, they don't have one in this case. All right, Mr. McCoy, looks like your underlying charges were criminal trespass, and 2 counts of simple battery. You've been advised of your right to remain silent, and your attorney is Miss Samantha Adams. Officer Allison, good morning.
Good morning.
All right, may I place you under oath?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. So we are first going to hear what are the reasons for the revocation, Officer Allison.
Mr. McCoy failed to report in the office as directed, did not complete 12 weeks of anger management, and failed to complete a drug and alcohol evaluation.
There's no way around.
Probation recommendation is to continue on probation, enroll in classes within 14 days, and the drug and alcohol evaluation will be due within 60 days and report to probation within 48 hours upon release. He does have 6 months and 28 days remaining.
Is this a first-time violation on this case?
I believe so, but I can look it up for you right now.
Appears to be.
Yes, it is.
Okay. Miss Adams, any objection? Are you on mute, Miss Adams?
I apologize, Your Honor. The computer here in courtroom 2 decided now was a good time to restart.
Okay.
So I did hear most of what Officer Allison said, but I did not hear the last thing you said.
Do you understand what was the state's position? To continue on probation, he needs to report within 48 hours, start his classes within 14 days, and do his alcohol and drug evaluation within 60 days.
Yes, Your Honor. If I can have just one moment.
Okay. If you want to mute, Miss Adams.
Yes, Your Honor. Okay, thank you, Your Honor. Yes, we do understand the position of probation, and there's no objection to reinstating his probation.
All right, this will be marked as a probation violation on the case. Mr. McCoy, you will be released to continue on probation in this case. You must report to the probation office by Monday, and that would be before 3 p.m. Once you report to probation on Monday, you will continue to report every month. If you fail, if you miss another report date, another probation warrant will be issued, and this time you might end up spending the rest of the time in jail. When you start reporting to probation, you must comply with your conditions. You must begin your anger management classes within 14 days of being released, and you must submit to an alcohol and drug evaluation. An alcohol and drug evaluation within 60 days of being released. Do not miss any more report dates, otherwise we will issue another warrant for your arrest. Thank you. Ms. Adams, is there anything else?
Nothing further, for Mr. McCoy. Thank you, Judge.
All right. Next case, please.
Position number 6, Tariq Gray, jail iPhone.
McLean, your case is on.
What's up?
Position 6.
Mr. McLean, good morning. This is Tariq Gray at the jail court iPhone. Do you see him, sir?
I do. Good morning, Your Honor.
Good morning. And we have Tariq Gray, case number 23 CR 6767Y, accused of loitering and prowling from October 27, 2023. Mr. Gray, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see Mr. McLean on the screen?
Yes, Your Honor.
All right, thank you. Is this still a non-negotiated plea, Mr. McLean?
It is, Your Honor. The issue here for Mr. Gray is the extra time.
All right. So, Mr. Gray, we are first going to hear from the prosecutor, and then I'll hear from your attorney. I'll tell you my decision as to which recommendation I'll accept, and then you can make your decision with the assistance of counsel as to whether you want to proceed with the plea. Ms. Dunlap, good morning.
Good morning, Your Honor. Thank you. So the state's recommendation on this is 12 months probation to serve 120 days, credit for time served 14 days, balance suspended, a stay away from 915 West Peachtree Street Northeast, that's Midtown Apartments, and no possession of any firearms or firearm replicas. And we can ask the defense to stipulate for venue, ID, and on factual basis.
For the purpose of plea, we certainly do.
All right, but if y'all stipulate to the factual basis, venue, and ID, I'm just curious to know why is the state asking for extra time?
Regarding this case, Your Honor, I'm sorry.
Is it something to do with his history or the particular facts of the case?
With his history, Your Honor, he had several, even though this was a replica firearm, he has an open burglary, several aggravated assaults. Sorry, Your Honor.
This is a loitering and prowling charge at the Midtown Apartments, correct?
Correct. If I could just briefly state the facts, then, Your Honor.
Okay.
The officers responded to an armed person call at 915 West Peachtree Street. They saw the defendant who matched the description given to 911. They recovered a replica assault rifle. The defendant was walking around the parking lot with the replica assault rifle. He was approaching moving cars with the gun in the hand and people. The management had placed the building on lockdown, and he had been asking people to use their phone to gain access to the building. It's reported he had no friends there or relatives or even a car in that parking lot.
Is he employed by security or anything to that effect in that area?
Not that I have any information, Your Honor.
Mr. McCoy? I'm sorry, Mr. McCoy. Mr. McLean. No idea why I'm
Very
thinking
good.
McCoy.
Your Honor, he and I discussed the definitions of loitering and prowling, and he decided it would be in his best interest to go forward with a plea. And he would like to ask the court. There was stuff going on. He met this person, his phone needed charging. She had his phone because she had a charger and he didn't. They were gonna get together maybe later on, but he was trying to find out if he could call his phone, which was not on him. If he could borrow a phone. There was a lot of stuff going on, but he says he had no ill intent and he understands the gist of the loitering and prowling statute. There's some fairly, it's a fairly vague concept sometimes, but nonetheless, he's thinking he would like to ask the court to accept his plea and see if the court would feel that the recommendation is too high. He'd like to ask the court to consider time served on the jail portion of the sentence, or at most maybe 2 or 3 weeks. Would that be reasonable for him to ask for?
I'll accept the defense's recommendation, but it will be balanced probated. He would need to do a firearm safety class, and he will continue to report to probation until it's 14 days, so it'll be for 11 and a half months. Would your client like to accept that?
I believe he would. That is within the range of possibilities we discussed.
And he understands that he needs to report every month and pay probation fees.
$49 a month. He does.
All right. Does he still want to proceed with the plea?
I believe so, Your Honor. Yes.
All right. Mr. Gray, please, Deputy, if you could unmute jail court iPhone, please. All right. Mr. Gray, if you please raise your right hand.
Your Honor.
You need to be placed under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, you may place your hand down. Have you consumed any medication or alcohol recently?
Your Honor.
Have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood what's been going on so far in your case?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And is anyone forcing you to take this plea in which you would be required to be on probation for 1 year?
No, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury, to confront your accuser, challenge the evidence brought against you, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of loitering and prowling?
Guilty, Your Honor.
Your sentence is 12 months to serve 28 days, credit for time served 14 days, which means that you will be released within 24 hours if you have no other cases holding you at the jail. You will report to probation next Thursday at 132 Mitchell Street before 3 p.m.
Yes.
Once you...
Your
Does it have a hold, Mr. McLean?
May I have a copy of that on document, Your Honor?
I can bring him any documents necessary later this afternoon. Your Honor, the package of information that we get on each person, it was kind of slim on him. It didn't have certain things, but I do have a booking sheet. And according to this booking sheet, this is the only thing holding him. It's just
Okay.
fine. Just
Thank
one
you.
line.
Your
All right.
Honor,
Yes, Ms. Dunlap?
he does have an Oakland burglary out of Fulton from February 9th.
Is that holding him at the jail, or is he out on bond on that one?
I can double
That
check.
the hold would be only if he has not bonded out on any other matters. But meanwhile, let me complete my sentence. Like I said, he'll be reporting to probation next Thursday if he has no other holds at the Fulton County Jail. While he's on probation, he will complete a firearm safety class, and the qualified classes can be provided to him by the probation officer. He will report to probation every month and pay the probation fees until the remainder of his probation time is completed. He is not to be in possession of any weapons or any firearms. He cannot have a firearm on his person, in his home, anywhere near him, or in any vehicle that he occupies. He is also to stay 200 yards away from the entire building known as 915 West Peachtree Street, otherwise called the Midtown Apartment Complex. He's not to be seen within 200 yards of that location. All right, Ms. Dunlap, did you have anything else to add?
No, Your Honor.
All right. Thank you. That concludes this case. Francois, am I going to another case in the courtroom?
Yes.
Case, please.
Position, this is gonna be probation calendar, position 5, Mr. Nelson.
Okay. Is that your client, Mr. McLean?
It is.
All right.
Your Honor, could I pause on mute for just a moment?
You may mute if you need a moment to confer. All right, I have an individual by the name of Jazz Fleming. Could you please start your video? All right, you have an inappropriate picture posted on your Zoom backdrop. You can either remove the picture or you can leave your video on. You need to unmute, Mr. Yes, sir.
We are ready.
All right. This is a probation revocation matter for Robert Nelson. The underlying case number is 22 CR 5937J. And Mr. Nelson, are you aware of the charge of which you've been convicted?
Good.
All right. And the probation violation case is 23 PV 1490. The prosecutors and defense counsel are advised that we're going to waive sounding on the conviction charge. Officer Allison, you're still under oath. And Mr. Nelson has been advised of his right to remain silent and his right to counsel. Officer Allen, what is the purpose of the revocation?
Mr. Nelson failed to appear to a prior hearing on February 23rd, 2023, failed to complete a psychosexual course, and did not complete a sexual cycle program. He has 6 months and 7 days left remaining on probation. Probation is recommended to continue on probation, report to the office within 48 hours upon release, and to complete the course within 45 days.
Mr. McLean, is that doable within 45 days?
Was that going to be start the class within 45 days or complete it within 45 days?
They indicate complete.
Complete. It'll be complete course.
He's
Okay.
got 2 courses to complete.
How long is the course?
Ms. Allison, are you familiar with the length of the program?
I am not familiar with the length of that program.
Okay. I'm going to amend the requirements. He has to show that he's enrolled in those classes within 45 days. And then he has the remainder of his probation to complete those classes. And every time that he reports to probation, he must show proof that he's attending those classes. So that way we're not stymied by the duration of the program.
Very good, Your Honor. Thank you.
Is that what your client would like to accept?
Yes, Your Honor. He has no objection to the recommendations and to the court's modification and would like to do that and be given a second chance.
All right. Mr. Nelson, this is going to be marked as a probation violation on this case. You are going to be released within 24 hours. You must report to probation on Monday before 3 p.m. If you fail to report, another probation warrant will issue. You will continue to report to probation every month until the conditions of your sentence are completed. More importantly, the 2 classes that you're supposed to have done, you must show that you have enrolled in those classes within the next 45 days. So by your second visit, you must show proof that you are making attempts to enroll. And by your 3rd visit, you must have enrolled in those classes. Then you have the rest of the term of your probation, which is 6 months and 7 days, to complete those classes. You must report every month and give us an update of your progress with those classes. If you fail to comply, we will issue another warrant for your arrest and you will complete the rest of your probation in jail. Thank you.
Probation, positions number 1 and 2, Mr. Claxton.
Thank you. We are Jail Court iPhone. This is Errol Claxton, who has a probation revocation matter. Mr. Claxton, my name is Judge Law. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is hopefully either Mr. McLean or Miss Adams.
I was just told that's Miss McLeod's case, but I don't see her signed on.
Oh dear. Okay. Deputy at the jail court iPhone. This is another case in which we are waiting on conflict counsel, Miss Maureen McLeod.
Your Honor, good morning.
Just 1 second, Deputy Milton. Jail court iPhone. Did you receive that message? All right.
Give her a call, Miss Blunt.
She's in Judge Edie's courtroom. As soon as she's finished, she's gonna log on.
Okay, I appreciate that. Thank you, Deputy Milton. Thank you. All right, courtroom 2, who do we have?
You ready for
One
my?
moment, Your Honor. You need a minute before I'm gonna tell you.
23, Mr. Lynn Ray in here. Position 23, Mr. Thomas.
One moment, Your Honor.
All right.
Your Honor, this is gonna be a negotiated agreement.
All right. I need to. Oops. Okay. This is position 23, correct, Ms. Adams?
Yes, Your Honor.
Okay. This is State versus Calvin Trayvon Thomas, case 23 CR 6765F. Mr. Thomas has 6 charges on this particular accused case, and they are public drunk, criminal trespass, an ordinance violation regarding certain acts on a transit station or vehicle, simple battery, and 2 counts of willful obstruction of a law enforcement officer. Mr. Thomas, you've been advised of your right to remain silent. Your attorney is Ms. Adams. And Ms. Falk, good morning. What are the offer for Mr. Thomas?
Yes, Your Honor. On count 1, the public drunk, it is 12 months served 30 days, credit for time served 14 days. From October 27th of 2023, balance probated, 40 hours of community service, ADET. On count 2, 12 months concurrent with count 1, stay away from all MARTA premises and property. Count 3 is going to be 12 months concurrent. Count 4 will be 12 months concurrent with 8 weeks anger management. Count 5 will be 12 months concurrent with a $300 fine, and count 6 will be 12 months concurrent. That will be a total of 12 months served 30 days, 14 days credit for time served, balance probated, 40 hours community service, 8-week anger management, $300 fine, stay away from all MARTA and ADET. The state would ask if the defense stipulates to venue, factual basis, and identification for the purposes of the plea.
Defense will stipulate.
All right. Mr. Thomas, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Mrs. Thomas, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Is anyone forcing you to take a plea offer today?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Has it been explained to you that if you decide to plead guilty to these 6 charges on the case, that you would be giving up your constitutional right to go back to court and have a trial in front of a judge or a jury to challenge these charges? You will not have the opportunity to confront your accuser, challenge the evidence brought against you, examine witnesses, present any defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 6 charges I've just listed?
Guilty.
Your sentence,
I have one question, I can't ride like harder anymore now. I'm doing it for like the rest of forever.
We're ready, Your Honor.
He understands that he has to stay away from all MARTA facilities for at least 1 year or in accordance with any suspension. Is that correct, Ms. Falk? Does he have a lifetime ban that you know of?
Not that I know of, Your Honor, but this stemmed from him already being told to leave the MARTA station. And then when the officer went and confronted him because he returned back onto the MARTA station, he tried to fight the officers and ended up slapping one of the officers' hands away. So we would ask that he be prevented from going back onto MARTA for the period of probation.
Okay. Mr. Thomas, you will have to stay away from all MARTA property until November 9th, 2024. After which, then you would have to ask MARTA whether you are allowed to get back on the property. Because I don't know if you have a lifetime ban by MARTA. All right. So shall I proceed with this?
Yes, Your Honor.
And actually, Your Honor, sorry to interrupt. Reading further into the report, it does say Thomas received a permanent ban from MARTA, which goes into effect immediately.
Well, there you go. Okay. Mr. Thomas, I'm going to give you a last opportunity to see if you want to withdraw your plea and proceed to a trial or whether you want to continue with the plea.
Like to proceed, Your Honor.
All right. As I was saying, with regards to the 6 charges I've listed, including 2 counts of obstruction of an officer and simple battery, how do you plead to the 6 charges?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 14 days. Looks like you have 1 more day to serve at the jail, after which you'll be released and placed on probation. You'll be on probation for 11 months. While you're on probation, your first date will be next Thursday at 132 Mitchell Street in downtown Atlanta. You must report to probation before 3 p.m. You will report to probation every month. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency. It cannot be a church and it cannot be a school, but you can select any other nonprofit agency. You must submit to an alcohol and drug evaluation and submit yourself to any treatment that's required, and you may do that at a facility like Grady Hospital. You are to stay away from all MARTA property, including bus stations, buses, trains, and train stations, including their facilities, which includes their parking lot and their bathrooms. You are not to be within 200 yards of any MARTA facility, and it appears to be a lifetime suspension. You're also to complete 8 weeks of anger management classes while you're on probation and pay a $300 fine. So you have the rest of the 11 months to complete these conditions. Thank you.
Thank you, Judge.
Next case, please.
Positions 1 and also 8, Mr. Hakeem Abdul.
1 and 8. All right, Mr. McLean, you are representing Mr. Looks like Hikal Abdul Rahman, and position 1 is 19 CR 007-488Y, accused of driving while license suspended, revoked, hit and run, and following too closely from an August 6, 2019 incident. And position number 8 appears to be same individual, the name's reversed, Abdul Rahman Hikal. And this is a bench warrant issued on February 23rd, 2023. Okay. And what are we doing today, Mr. McLean?
Your Honor, he was outsourced to Cobb County, so we got a chance to speak this morning and go through the accusations and the reports. And he'd like to enter a negotiated plea of guilty this morning.
All right. And I'm assuming that the state will null cross a bench warrant if that moves forward.
Yes, I believe they will.
Ms. Dunlap?
Yes, Your Honor.
Okay. Mr. Abdul Rahman, if you have been advised of your right to remain silent and your attorney is Mr. McLean, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. McLean, just to clarify, is his last name Abdul Rahman?
Yes, Your Honor, there is no hyphen. The last name is Abdul Rahman.
Okay, thank you. Ms. Dunlap, what is the plea offer, please?
On count 1, we're asking for 12 months probation. Concurrent with the count 2, they were asking for $1,000 fine on that, a 6-month suspension of his license. Count 2 is 12 months probation to serve 66 days, credit for time served 33 days, and that's from August 24th, 2019 to August 26th, 2019. And then from March 16th, 2021 to March 17th, 2021. And then from October 13th, 2023. Also a defensive driving course. We were asking for restitution to the victim, but victim advocate spoke to her. She said that in her insurance paid, she's no longer seeking restitution. $300 fine. Her count 3, it's 12 months probation, concurrent with count 2, and a $265 fine. So the total is 12 months probation to serve 66 days, credit for time served 33 days, defensive driving course, no longer need a restitution to the victim, and a $1,565 fine.
$1,565 fine.
Correct. And that's
and this is concurrent, right? So it's 12 months probation or less 66 days.
Correct, Your Honor.
Okay.
And we'd ask the defense to stipulate to ID, venue, and factual basis.
For the purposes of the plea today, we certainly do so stipulate. Your Honor, I should warn Mr. Abdul Rahman that there are sometimes surcharges associated with fees, and that they can be considerable. That could be a fairly high percentage of the 1565.
Does he understand that his license will be suspended and that he would need to also go through the program to get it and reinstate it, which is
Yes.
not in itself inexpensive?
Yes, Your Honor, he does.
All right. Are we still proceeding with the plea?
Yes.
All right. Mr. Abdul Rahman, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
With regards to these 3 charges, it will have a negative impact on your driver's license. Are you still freely, willingly, and knowingly going to enter a plea today?
Yes, ma'am.
Do you understand that if you plead guilty to these charges, that you will be giving up your constitutional right to a trial, to confront your accuser, challenge the evidence and witnesses brought before you, and have the state try to prove the charges against you, and give up your right to have the state prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
And you're willing to give up these rights?
Yes, ma'am.
How do you plead to driving while license suspended or revoked, hit and run, and driving following too closely?
Yes.
Your sentence is going to be 12 months to serve 66 days, credit for time served 33 days, balance probated. While you're on probation, you will pay a total of $1,565 plus probation fees and any surcharges. Your fine, and you also will need to do a defensive driving program. Required to be on probation for a minimum of 6 months. Which is the duration of your license suspension. If you have completed all these conditions, then your probation may be non-reporting.
Yes, ma'am. I understand.
That concludes your case. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Mhm.
Okay. What do you need? Move it along.
Position 7, Renil.
Okay. Okay,
Oh, he's not ready.
not
He is not seen, so we have to review.
I'm sorry, Mr. McLean, could you repeat that announcement?
Mr. Grinnell was in a zone that had a problem, so we need to see him today and announce.
Okay, so you still need to talk to him. Is there
Right.
another case that we can address with you or Miss Adams?
Your Honor, I am almost done with Mr. Porter. It's gonna be a plea. I just need to fill out the paperwork.
Are you ready for Mr. Lyons, position 15?
Okay, we are ready for Mr. Lyons.
It's gonna be position 15, Lyons.
What's the announcement for position for Mr. Lyons?
It's gonna be a plea, Your Honor.
This is State versus Yoram Nevon Lyons, 23 CR 6753C. Mr. Lyons was accused of criminal trespass causing damage to property and willful obstruction of a law enforcement officer. Mr. Lyons, you've been advised of your right to remain silent, and your attorney is Ms. Samantha Adams. This is going to be a negotiated plea. Mr. Lyons, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Repeat.
Yes, ma'am.
Thank you. Ms. Falk, what's the terms of the offer?
Your Honor, the recommendation is on count 1, 12 months served, 90 days, credit for time served, 15 days from October 26, 2023. Balance probated. We're asking for a stay away from 8601 Roberts Drive in Sandy Springs. No further contact with Ashley Cameron, and restitution remain open for 30 days. We are also requesting an MHET on count 2, 12 months concurrent with count 1. The state would ask the defense to stipulate to factual basis, venue, and identification for the purposes of the plea.
So stipulated.
All right, just a housekeeping matter. How would we address restitution?
Well, it would remain open for 30 days. If she does produce a restitution document, we would have to have a restitution hearing.
And who would be requesting that hearing?
Well, if the defense does not agree to the restitution that is provided, then the state would need to request the restitution hearing.
Okay. All right, and I'm assuming that would go on a SAP calendar or I'm just curious which calendar is it going to go on, or are you going to go with the division judge?
It would need to go on the SAP calendar since I would need to go back before the judge that heard the plea.
Okay. All right. Ms. Adams, you have stipulated to the factual basis, venue, and ID. So, Mr. Lyons, number 1, have you consumed any medication or alcohol?
Oh, ma'am.
And have you understood what's been going on so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
And Mr. Lyons, do you understand that your case is going to remain open for at least 30 days to have another hearing if the victim produces evidence for restitution?
Yes, ma'am.
Do you know what restitution means?
Paying for damages caused losses.
Absolutely correct, yes. So are you still willing to move forward with this plea offer?
Yes, ma'am.
Okay, so you understand you have to be available to attend a hearing within the next 30 days if you are summoned to attend. Do you understand?
Yes, ma'am.
Okay. And you will also have to give up your constitutional right to a trial. You will not be able to have a trial by a judge or a jury. You will not be able to confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass causing damage to property and 1 count of willful obstruction of an officer?
I plead guilty.
The sentence is 12 months to serve 90 days, credit for time served 15 days. You have additional time to serve at the jail. Has your attorney told you How many more days?
Plus 30 days.
Okay.
30 days.
Once you have completed the additional time, you must report to your probation officer, and that must be done within the first week that you are released. You can go there on a Monday, a Tuesday, or a Thursday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. When you are released from jail, make sure that you keep in touch with your attorney to find out when you are supposed to report to probation. While on probation, you will stay away from the 8601 Roberts Drive, and you are to have no contact with Ashley Cameron. You're also to attend and complete a MHET, which is an evaluation that you'll have to take and submit yourself to any treatment that's required. Count 2 will be concurrent to count 1. Thank you.
Your Honor, if I may, I apologize for not asking for this before because Mr. Lyons did used to live there. We are requesting a one-time police escort to gather his belongings from the home. He also shared a child with her, so I don't know if he has not yet been legitimized. So I'm not sure if the court would be willing to give him third-party contact for the child.
All right. I will let him have a one-time visit to the location with a police officer. He must be in the company of a police officer to retrieve his belongings, and that visit cannot exceed 1 hour. If he plans to have visitation and joint custody with the child or children that he shares with Ms. Cameron, he must file a legitimation action in the appropriate superior court and obtain a court order for visitation and custody. Thank you. Is Maureen McLeod, what time is it? It's 9:49. I've got a hold till 10 a.m. So we're going to hold for Miss McLeod until 10 a.m. Jail court iPhone, I believe that's Miss McLeod's client.
No, I have position 3 and 4, Collins. I didn't stay with McLeod's client. I came on up to another floor.
Okay. 3 and 4, is that Mr. McLean's client?
Yes.
Okay, just give me a moment. Mr. McLean, will we be able to proceed with positions 3 and 4 on a plea, negotiated plea?
I hope so, Your Honor. I believe that he understands he certainly has been told and informed and discussed the terms of the recommendation. And I explained to him the difference between a negotiated and non-negotiated plea. And he would like to go forward, I know.
Okay. This is State versus Christopher Collins. Mr. Collins is appearing at the Zoom panel identified as Jail Court iPhone. Mr. Collins, my name is Judge Lal, and this is a plea hearing. You have a right to remain silent about the facts of the case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see Mr. McLean on the screen?
Yeah, I see him.
Do you see it?
Yes, ma'am. Yes, ma'am, I see him.
I need to place you under oath for this plea hearing. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Dunlap, Mr. Christopher Collins has got 2 cases, 23 CR 137J, in which he's got 2 counts of cruelty to animals, tethering, no Fulton County license tag, and no proof of current rabies vaccination. His other case is 23 FTA 995, which is a bench warrant. Well, I hadn't had these kind of cases for a while and a bit. So what's the plea offer?
For count 1, Your Honor, we are 12 months probation to serve 56 days Credit for time served 28 days, and that's from the 13th of October, 2023. Balance probated, a $500 fine, 50 hours community service, complete a BARC animal cruelty online course,
Mhm.
and he cannot own animals or have animals in his household.
Okay.
For count 2, 12 months probation probated, concurrent to count 1, non-reporting, also cannot own animals or have animals in the household. Count 3, 12 months probation, this is probated, non-reporting, can't own animals or have animals in the household. Count 4, 12 months probation probated, concurrent to count 3, non-reporting, still cannot own animals or have animals in the household. Count 5, 12 months probation, concurrent to count 4, same non-reporting, cannot own animals or have animals in the household, for a total of 60 months probation. 6. I'm sorry, they're not concurrent. These are consecutive. I'm sorry, I was reading that wrong. So for a total of 60 months probation, 56 days to serve, credit for time served, 28 days, balance probated, non-reporting after a year, $500 fine, 50 hours community service, complete a BARC animal cruelty online course, and cannot own animals or have animals in the household. And for position 4, NP on a plea to position 3. And we ask the defense to stipulate to venue ID and factual basis.
For the purpose of the plea today, we certainly do stipulate to factual basis, venue, ID. I do need to point out one thing, but we're not trying to mess up a negotiated plea. I'm not sure that when a tag, failure to have the tag, the license tag on the neck of the animal, I'm not sure when that converts over to state court, whether it really could carry 12 months. But if it can, he understands and is willing to go forward. But I feel obliged to just point that out, that I'm not sure that really can go that high. I would have to research that. I could be wrong. My misgivings might be wrong. But he would like to do a negotiated plea. And if that messes it up, I mean, really about 48 months of not having an animal is very similar to 68 months.
It's a quirky thing, but the tag issue is the ordinance violation up to 6 months, and the rabies vaccination is a state charge up to 1 year. Well, who knew? But you know, like I said, it's a quirky thing. So really be
4.5 years?
54 months.
Right, 54. There we go.
I don't know, Mr. McLean. My math teacher is still not happy with my grades, but I'm going to go with 54 months.
You're right.
Ms. Dunlap, any objection to reducing the consecutive probation for new no county tags to 6 months?
No objection, Your Honor.
All right. Now that I've tested the length and breadth of my mathematical skills, Mr. McLean, you've stipulated to the factual basis, venue, and ID. Mr. Collins, have you consumed any medication or alcohol recently?
No.
And I assume you've had a long conversation with your attorney about this case, correct?
Yeah, I talked to him yesterday.
All right. And you understand that you will be on probation for 54 months.
Okay. Okay.
And that you're not allowed to own any kind of animal, or any kind of pet, any kind of non-human being species, living species in your home.
Okay.
You're not allowed to own that anywhere, not just in your home. So I don't want to give you the impression that you can own a dog somewhere else and live somewhere else.
Okay, yeah, okay, cool.
I'm sorry?
Okay, what you're saying is I can't have it in my house. You have another house?
You
Right.
cannot have a pet anywhere, not in
Okay.
your home, not in another house. You
Okay, well,
cannot be
that's all right.
responsible for any animal for 54 months.
Okay, all right, yeah.
You know, if
Look.
I may interject, if I may interject. Mr. Collins, it means that if you have to give up other pets to other people, that giving up of the pets has to be real, and you can't control the pets. If you give any pets away to relatives or friends, they are the owner and you have no say-so about that animal whatsoever. Okay?
Yeah.
Okay.
Oh, if he owns any pets right now, they all have to be given up. He can surrender them to animal control, or he can find someone who's suitable enough to look after them.
They all at shelter until 54 months. Yeah.
All right, then you're not allowed to go to the shelter
Okay, I can't get them back to 54 months.
for 54 months.
Okay, all right.
You will also be responsible for a $500 fine and 50 hours of community service, and do a class that is called BARC, is an animal rights and control course which is online. Do you understand that you would have to do all that?
Yes, I can understand that. Yeah.
Okay. Has anybody forced you, induced you to take this plea today?
I'll say it again for me, ma'am.
Is anybody forcing you to plead guilty to these charges today?
No, I am.
Are you doing so freely, willingly, and voluntarily?
Yes, ma'am.
And it's been explained to you that if you decide to plead guilty, you will be giving up your rights to have a trial in front of a judge or a jury, to go back to court to confront your accuser, challenge the witnesses and the evidence that will be brought before you, have the assistance of counsel to present any arguments, defenses, or mitigating factors if you choose to do so, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes. Yes,
Are
ma'am.
you sure?
Yes, ma'am.
How do you plead to 2 counts of cruelty to animals, 1 count of tethering, 1 count of failure to have Fulton County license tags, and 1 count of no proof of current rabies vaccination? Repeat.
I say I plead guilty, Miss Long.
Your sentence is going to be 12 months to serve 56 days, credit for time served 28 days. If you have no further holds at the jail, you'll be released, and you report to probation next Thursday at 132 Mitchell Street before 3 p.m.
Okay.
While you're on probation, you will report every month. And while you're on probation and reporting probation, you will finish paying off a $500 fine plus your probation fees, complete 50 hours of community service at any nonprofit agency. You cannot do, pay attention, you cannot do community service at a church, at a school, and any kind of animal shelter or animal protective agency. Do you understand?
All right, I get you. Yeah.
You cannot own any pets. You have to give up all pets that you currently own, and you cannot retrieve any of your pets from any kind of animal shelter or protective agency. If you plan to donate your pets to somebody else who is suitable to look after them, then they may retrieve the pets from the shelter with your written permission, but you yourself cannot go and retrieve those pets.
Yeah, I can retrieve the pets. How long would it take?
You cannot retrieve the pets.
Okay, that's fine.
You're not allowed to be near them. You're not allowed to touch them. You can give an affidavit to your friend and say, here, you have my permission to go get, Scotty or whatever your pet name is. Do you understand?
Yeah.
For the remainder of the 1, 2, 3, 4 charges on the second count of cruelty to animals, that will be 12 months probation consecutive. For the tethering, is going to be 12 months probation consecutive. For the no Fulton County license tag, that's going to be 6 months probation consecutive. And for the no proof of rabies vaccination, that's going to be 12 months probation consecutive. That's a total of 56 months probation, less 56 days. And once you've completed the paying the fine, you're current on your probation fees, you've completed the community service and the online program, your probation will be non-reporting. But the no pet rule still remains in force.
Okay, yes, ma'am.
All right, thank you.
Your Honor.
And Just one second. Yeah, he didn't have an FTA. Okay, we're good. Yes, Ms. Dunlap?
I just verify, you said 56, 54 months
Oh,
total?
54 months. You told, see, I told you math. Okay, so sorry. It's 54 months probation. Miss Grace, I'm so sorry. You have to use that white out quite a bit.
It's Miss Strong, but I have it.
Oh, Miss Strong. Okay, sorry about that. Yes. Okay. All right, jail court. I'm going back to courtroom 2. Francois, do we have anyone who's ready?
Position 17, Mr. Porter.
This is State versus Donna Misi. Is that correct? Donna Misi Porter? Donna Meach. Okay. Donna Michi. Did I say that right?
Yes, ma'am.
Okay. State versus Donna Michi Porter, who has 2 cases before us. Mr. Porter, you have a right to remain silent as advised, and your attorney is Miss Samantha Adams. And 17 and 18. Miss Adams, how are we proceeding in these 2 cases?
Be a negotiated plea, Judge.
All right. I assume it's going to be a plea on position 7 and a null pros on position 17, excuse me. All right, Mr. Porter, could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, this is going to be a negotiated plea hearing on 23 CR 4353B, in which he was accused of battery, family violence, and criminal trespass, causing damage to property on July 10th, 2023. Ms. Falk, what are the terms, please?
Yes, Your Honor. The terms are on count 1, 12 months served 60 days, credit for time served 39 days. That's going to be from July 10th, 2023 to July 19th, 2023, and then from October 12th to today. The balance will be probated. Stay away from 3030 Continental Parkway Southwest. No further contact with Cleothella Fleming, and Family Violence Intervention Program. On count 2, we're requesting 12 months to run concurrent with count 1. We did speak with Ms. Fleming, who I believe that maybe who's here on the Zoom under Jazz Fleming. And she did agree with the plea offer and stated she was not seeking any restitution. If Ms. Fleming would like to speak, we would like to sound for her, and we would like this defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
So stipulate. All right, thank you. Ms. Fleming, yes, good morning. Did you want to add anything to this proceeding, or are you in agreement with the terms of the sentence?
I am in agreement with the terms of the sentence.
All right, I appreciate it. Thank you very much. All right, Mr. Porter, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Is anyone forcing you or inducing you to take this plea offer today?
No, Your Honor.
Are you satisfied with your attorney services?
Yes, ma'am. Yes, Your Honor.
And if you decide to plead guilty to these charges, it will be 1 count of battery, family violence on your conviction record. Do you understand that?
Yes, Your Honor.
And has it been explained that if you ever get arrested again for a same or similar offense, that it will be automatically a felony charge?
Yes, Your Honor.
All right. Are you still willing to move forward with this plea?
Yes, Your Honor.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury, to have the assistance of counsel to be able to confront your accuser, challenge the evidence brought against you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of battery, family violence?
Guilty.
And how do you plead to 1 count of criminal trespass causing damage to property?
Guilty.
On the battery charge is 12 months to serve 60 days, credit for time served 39 days. If you have no other holds, you'll be released within 24 hours, and you must report to probation next week on Thursday before 3 p.m. The probation office is at 132 Mitchell Street in downtown Atlanta. At all times while you're on probation, you cannot return to the entire complex at 3030 Continental Parkway. You're to have no contact at all with Miss Cleo Fleming. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner, including electronic devices and social media. Within 30 days of being released today from jail, you must enroll in a domestic violence intervention program, which is a 24-week class program. You must pay for those classes out of your own pocket. Your sentence for the trespass causing damage is going to be 12 months probation concurrent. That concludes the sentence. Thank you. And on count position 18 on the bench warrant, it will be null prost.
Find your next. Position 5, Edwards.
Okay. Mr. McLean, you've had an opportunity to have a conversation with Mr. Edwards.
Yes, Your Honor, we have.
And your announcement?
This is a negotiated plea.
State versus Lamoris Lamont Edwards, 19 CR 3832F, is accused of theft by receiving stolen property from April 24th, 2019. Mr. Edwards, you have a right to remain silent as advised, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Dunder?
Thank you, Your Honor. The state is looking for 12 months probation to serve 60 days, credit for time served 31 days, and it's from April 24th, 2019 to May 15th, 2019, and then from March 26th, 2020 to April 3rd, 2020, balance probated, an anti-theft course, and no further contact with the victim, a Robert Schreon, Scheon. And we ask the defense to stipulate to venue, ID, and factual basis.
For the purpose of the plea today, we certainly do stipulate to those three elements, Your Honor.
Mr. Edwards, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Is anyone inducing you or forcing you to take this plea offer today?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to accept this plea offer and plead guilty, you will have to give up your right to a trial in front of a judge or a jury to be able to go into a courtroom with your attorney and confront your accuser, challenge the witnesses and the evidence, present any defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you willing to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by receiving stolen property?
Guilty.
Your sentence is 12 months, serve 60 days, credit for time served. I think it was 31 days. Was that correct?
Correct. Yeah,
okay. The remainder of the time will be on probation. If you have no other holds, then you will be released within 24 hours to report to probation next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete an anti-theft class, and that must be completed within 60 days of being released from jail. You will, while you are on probation, you will also have no contact with Robert Schoen, which means staying 200 yards away from him and not communicate with him in any way, form, or manner. Thank you.
Your Honor, this is ACDC. Before you is Miss Charity Jones, Mr. Mike McLean's client.
Okay, thank you, Deputy Milton.
You're welcome.
Okay. Have we heard from Miss McLeod by any chance? No? All right, Charity Jones. Ms. Charity Jones, my name is Judge Long, and I'd just like to remind you and the young lady behind you as well that both of you are here at the state all-purpose calendar. You have a right to remain silent about the facts of the cases pertinent to both of you. Anything that you choose to say in open court about your cases, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Ms. Jones, you have two cases before us. The first one is position number 10, in which you are accused of criminal trespass causing damage to property from February 16th, 2023. The second case is a bench warrant for failure to appear, 23 FTA 964, and appears to be from October 10th, 2023. Ms. Jones' case is going to be, let's see, is this going to be a arraignment, Mr. McLean?
Yes, Your Honor, we waive the formal reading of the accusation and plead not guilty.
All right. Ms. Jones, it appears that you'll be entering a not guilty plea. As I've indicated, you are charged with this misdemeanor offense. Upon your entry of your plea, your case will be scheduled for trial. At the time of the trial, the prosecution would have the complete burden to prove the case against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecution prevails, you could be found guilty and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
I'm sorry, could you repeat?
Not guilty.
All right. Your case has been arraigned. Both cases will be further notice for trial. Thank you.
Our bond request, Your Honor, is simply that there's something else holding her that she cannot afford. And I have two ideas behind the request for bond reduction. One is a practical one, that if she can make a $30,000 bond, it's not going to make much difference whether there's 2,000 there or not. But it appears the family is trying. It would help somewhat to make this $2,000 bond matter a signature bond. Secondly, Your Honor, in terms of substance, she has 6 children. She would love to be home helping take care of them. Her relatives are doing so. They are 12, 9, 7, 5, 2, and 7 months. And she really, really would like to be home. She was, while I'm not going to name schools or anything with personal information, nonetheless, Your Honor, she discussed with me details that indicate to me that she's certainly on top of all her family matters and would do well for her children by being home. She has worked in the past as a cashier and service manager, customer service desk manager at a Publix, and she was applying for a job with Allied University when this came up.
All right. And from what I gather, well, she's got the bench warrant, which is the battery charge a Superior Court matter?
The other matters are Superior Court matter, and she will be assigned a felony attorney for that, and they'll be making a bond request on that.
I'm just trying to see whether she was just arrested on the on this particular bench warrant. Yeah, it doesn't appear to be so.
I think not.
All right, Ms. Dunlap, we have a request to modify the bonds for criminal trespass and the bench warrant to a signature bond. But she's got other matters holding her in Superior Court.
Correct, Your Honor. If I may briefly, the fact of the case, officers arrived on February 6, 2022 to a 2788 DeForest Ferry Road, Northwest. They spoke to a property manager. Her name is Kayla Edison. She stated that there was a male and female dispute at apartment 363. The defendant broke the window, and the apartment values the window around $340. Officers attempted to speak to the defendant to ask what's going on. She stated that the male in that case was Corinne Rogers, had her key and wouldn't give it back. She told the officers that she broke the front window using a car jack. She was detained because she continued to speak over the officers, and the officers asked her to stop several times so they could figure out what was going on. She stated she did this because Mr. Rogers was cheating on her and he asked her to leave. Her 3 kids were apparently in the car when this happened. The state was looking for a 12-month probation to serve 45 days, credit for time served 23 days, and that was from February 16th, 2022, February 18th, 2022, and then from July 20th, 2023 to July 24th, 2023, and again from, it looks like October 25th, 2023 to today, balance probated. We had asked for restitution open for 30 days to Quintus Corp. That's the property. The defense would like to withdraw that recommendation on record. We're asking for the bond to stay the same. She does, like we mentioned before, has another criminal damage to property in the 2nd degree open, terroristic threats, harassing communications from, it looks like April 21st of 2023. And she also failed to appear on the 9th, so her bond was surrendered.
Yeah, I think that was Judge Richardson's bench warrant for $2,000.
Correct, Your Honor.
Mr. McLean, I'm going to deny your request for a bond modification. I'm going to stay with the same bond that was set by Judge Richardson. This is her 2nd arrest in 2023 alone. I'm not certain what's going on with this young lady, but she is proven a track record to reoffend just within 1 year and not showing up in court. Thank you.
Understood. Thank you.
Can I say something?
No.
Thank you.
Position number 9, Joan Louise.
I'm sorry, Your Honor, if I may, while ACDC is grabbing that other person, I don't know if position, his name is Oluwatabi Oyetola. I believe he is position number 16 on the calendar. I don't know if he's in medical. Somebody I had not had an opportunity to speak with, because he was brought out. If he's on the Zoom, I was wondering if I could please have a breakout space so I can speak with him.
Well, let's find out. Jail court iPhone, who do we have, please?
Position number 9, Joan Louise.
Okay, that would be Mr. McLean's client. By any chance, do you have position 16, Mr. Oyetola?
Who?
Oyetola.
Oh.
Okay, so Miss Adams, until he's produced either in courtroom 2 or one of the other locations, I wouldn't be able to advise you as to when I can authorize a breakout session.
Yes, thank you, Your Honor.
All right, but if you let Deputy Francois know who you're trying to have produced to confer, I mean, she can make the necessary calls.
Yes, thank you, Judge.
All right. Jail court, we have position number 9. ACDC, I'll be right back with you. And this is Willem Jean-Louis, accused of criminal trespass in case 23 CR 6762F from October 26, 2023. And Mr. McLean, whenever you're ready. Just waiting on Mr. McLean to appear.
There we go. Scoot around the corner, Your Honor.
No problem. All right, Mr. McLean, I've already announced for your client, Willem Jean-Louis, position number 9. And I understand this is going to be a negotiated plea. Is that correct?
Correct.
All right. Jail court iPhone, please unmute.
Yes, Your Honor.
Mr. Jean-Louis, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Right. Thank you. Ms. Dunlap, what are the terms for Mr. Jean-Louis's charge of criminal trespass?
Your Honor, the state is looking for 12 months probation to serve 30 days, credit for time served 15 days, and that's from the 26th of October, 2023, balance probated, 40 hours community service, and a stay away from 1105 Holcomb Bridgeway. That's an Exxon gas station He previously criminally trespassed there in May 11th of 2023. We asked the defense to stipulate for venue, ID, and factual basis.
For the purpose of the plea, we certainly do.
Mr. John Lewis, have you consumed any medication or alcohol recently?
Yes, I have a prescription right now on me, so I got to go to Grady Hospital as soon as I get out of here on the 13th floor. Now that I remember what floor to get it on. Last time I didn't remember what floor should I get my medication on.
Okay. But after consuming that medication, are you still able to understand what's going on so far in your case?
Yes, Your Honor.
Have you spoken to your attorney, Mr. Michael McLean, recently?
Yes, Your Honor.
And do you understand why you are here today?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And is anyone forcing you or inducing you to plead guilty to the charge of criminal trespass?
No, Your Honor.
And has it been explained to you that if you enter this plea, you will be giving up your right to a trial in front of a judge or a jury, to be able to confront your accuser, have your attorney help you to challenge the evidence and the witnesses brought before you, to be able to present any defenses, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of criminal trespass at the Exxon gas station on Holcomb Bridge Road?
Guilty, Your Honor.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other cases holding you at the jail, you'll be released within 24 hours. You must report to the probation office next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service, and you must also stay 200 yards away from the Exxon gas station at 1105 Holcomb Bridge Road. Do you understand your sentence?
Okay, yes, Your Honor.
You understand that you cannot return to that Exxon gas station ever?
Yes, Your Honor, I understand.
And you must report to probation next Thursday?
Yes, Your Honor.
Okay.
At 9 o'clock.
Before 3 p.m.?
Yes, Your Honor. Excuse me.
All right. If you have no other questions, that concludes this case.
Thank you, Your Honor.
Thank you. All right, ACDC, who is the next person, please, Deputy Milton?
Ms. Robinson, but she is Attorney McLeod's client.
Okay, I have to hold on that then. Jail court iPhone, did you? Courtroom 2, do you have anyone?
There's one more person in here, Mr. McLean is in the middle of speaking with, Judge, but I did find out with regards to position number 16, he has actually been brought over to Grady.
16, I'm so sorry. I have Mr. Oyetola is not available.
Yes, Your Honor. So we'll be requesting a reset because he's a Grady.
All right, this will be a reset to November 16th, which is next Thursday.
Thank you, Judge.
All right. Okay, let's, you can mute Miss Adams while I just inquire about Miss McLeod. Miss Grace or Miss Strong, any updates? Sorry, I should check.
I'll see with Miss Grace. I'll check with her. Just give us a moment.
She was in Judge Edie's court, so I didn't know if she was still planning to show up. So
Okay, I'll see if Miss Grace has spoken with you.
all right. All right, Mr. McLean is speaking to his client in courtroom 2. I have a couple of people on jail court iPhone waiting on Miss McLeod and ACDC waiting on Miss McLeod. Are there any other cases or any other locations that need to be addressed?
Judge Law, we still have one case with Mr. McLean It's gonna be position number 7. He's still interviewing his client.
Yeah, that I made a note of that we're waiting on Mr. McLean to finish talking to his client.
Your Honor, I'm handling position number 14. I don't know if that's medical, that's Mr. Ray Lynn. That's gonna be a plea. And also I'm also handling positions number 20, 21, and 22. His name is Justin Smith.
Okay, let me just go over the calendar with you, Miss Adams. Your cases start from position 14, right?
I believe they start with 12. Give me 1 second, Judge.
Yeah, that's my cheat sheet. No, you're correct. It starts with 12.
Yeah, it starts with 12, but
Okay.
Mr. Lewis was released.
Okay, so position 12, Benny Lewis is released. So that is going to be further notice for trial. What about position 13?
It's the same person, Judge.
Oh, I'm sorry. You're right. Okay, and 14 is Ray Lynn, and that's the one that you're waiting.
Your Honor, I believe he may be in medical. I see medical on the Zoom call, but whenever the court is ready.
All right, let's see if we get to position number 14.
Judge Law, we're ready for position 7. Grinnell, have a seat over there.
All right, Deputy Francois, can you check on position 14 also with medical? Ray Lynn, I don't know.
That's gonna be Miss Blanche. She's the roving
I'm trying to get him out now. I need a key. I'm getting him now.
No
Stand by.
rush, no rush. Just trying to get an update. Thank you, Deputy. All right, position number 7, we have Mr. McLean's the client, and that's going to be DeAndre Rashad Grinnell. Case number 23 CR 6438G. Mr. McLean, your client is accused of battery from October 17th, 2023. Mr. Grinnell, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Michael McLean will be representing you. And what's the announcement, Mr. McLean?
Negotiated plea, Your Honor.
All right. Mr. Grinnell, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Dunlap, what are the terms?
Thank you, Your Honor. The state is looking for 12 months probation to serve 60 days, credit for time served 21 days, and that's from the 20th of October, 2023. Balance probated, a 12-week anger awareness course, 40 hours community service, no further contact with the victim, a Miss Christy Chang, a stay away from 550 Peachtree Street Northeast, that's Emory Hospital, unless for medical treatment. And we ask the defense to stipulate for venue, ID, and factual basis.
And that was Christy Chang, C-H-A-N-G?
Yes, Your Honor.
All right.
We do so stipulate, Your Honor.
All right. Mr. Grinnell, have you consumed any medication or alcohol recently?
Only my subdued medication. Your Honor.
Okay. And after taking the medication, are you still able to understand what's been going on so far in your case?
Yes, I am, Your Honor.
And you've spoken to your attorney. Are you satisfied with his services?
I am satisfied with my attorney services, Your Honor.
Okay. And is anyone forcing you to take a plea offer today?
No one is forcing me to take a plea offer today, Your Honor.
And I'm sure Mr. McLean has gone over your rights. Are you freely and willingly and knowingly prepared to give up your constitutional rights, which include the right to a trial before a judge or a jury, to confront your accuser, the right to come to court and challenge the evidence and the witnesses brought before you, the right to present any arguments, defenses, and mitigating factors if you choose to do so, and the right to have the state prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. Are you prepared to give up all these rights?
And they already argued the rights, Your Honor.
I didn't understand your response. Are you prepared to give up your rights that I've just listed?
Yes.
How do you plead to one count of battery from October 17th, 2023, allegedly at the Emory Hospital on Peachtree Road?
Not guilty.
So you want a trial?
No, I don't want to do a trial.
I'll ask you again, but listen very carefully. How do you plead to one count of battery
it's not guilty, with the plea that I already put in, guilty.
I probably should talk to him a little bit further, Your Honor, if we can
I'm sorry
pause.
about that. You're supposed to say guilty.
Hold on, we're gonna discuss this.
Mute
If
screen,
I could
Mr.
mute
McLean.
it. Okay, let's mute.
Ms. Strong or Ms. Grace, any updates from Attorney McLeod?
Oh, yes, ma'am. I sent you a message in the chat. I'm sorry. She said that Ms. McLeod had Judge Edie and Judge Mather this morning. So
Does she want me to reset these cases?
she did not say that. She didn't state that. She just said it would be after, like about 10ish or maybe after before she got on here, but didn't give a definite time.
All right, I'll hold till, well, I think I have a calendar at 11 o'clock, so let's see what happens.
Okay.
By the way, Miss Falk, are you doing the 11 o'clock calendar with me? Miss Shelley Falk?
I am, Your Honor.
All right, and I was just wondering, Mr. Derek Smith will be available as well.
Mr. Howard should be here shortly.
Not Derek Smith, Derek Howard, sorry. All right, it's one of those days. Okay, thank you. Mr. McLean, before I call you another name, let's see if we can proceed with this plea. Are we ready to move forward?
Oh, we certainly are, Your Honor. He was just a little mixed up on our terminology. He is doing quite well in his meds. He's been having several days, and I believe he does understand.
All right. Mr. Grinnell, I'm glad you've had another conversation with your attorney. Currently, you're charged with battery involving an incident at the Emory Hospital with an individual of Christy Chang. If you decide to plead guilty, this will be a conviction on your record, and you would need to stay away from that hospital and that person, as well as be on probation. Is that been explained to you?
Yes.
How do you plead to one count of battery?
Guilty.
Your sentence is 12 months to serve 60 days. Credit for time served, 21 days. You have 8 more days or 4 more days, Mr. McLean?
I think 9.
Okay, he has 9 more days at the Fulton County Jail before he can be released to probation. Once you are released, Mr. Grinnell, you have to report to probation. You can report to probation the following week, either on a Monday, a Tuesday, or a Thursday.
Where
Probation, the probation office is at 132 Mitchell Street in downtown Atlanta. Do you follow me?
Okay.
Do you understand?
Yes, ma'am. Yeah, yes, Your Honor.
While you're on probation, you must report once a month for at least 10 months.
Okay.
And while on probation, you will complete 12 anger management classes. You will complete 40 hours of voluntary community service at any nonprofit agency, but it cannot be a church and it cannot be a school.
He said that they wanted to start a program at Gateway. Is that where I can
Gateway is
Housing is going to be at Gateway.
all right. That is a possible program, but you must make sure you do 40 hours of community service there. You are to have no contact with the individual Christy Chang, and you are to have no violent contact with the staff at the Emory hospitals. Do you understand?
Upon release, Your Honor, I want to ask, would it be possible, can they get my wallet back from the Emory Hospital?
Let me finish. You cannot return to the Emory Hospital at 550 Peachtree Road unless you have an appointment or you are seeking emergency treatment. Do you understand?
Will they get my wallet back because I don't have my identity if I don't have my wallet?
Did you understand the stay away?
Yes, Your Honor, I do understand what you're saying.
You are allowed a one-time visit to that hospital with a police officer.
Will they get my wallet back?
By appointment, you're going to ask for that, yes. You're going to make an appointment, and you're going to meet with the police officer at the place or wherever they say, and hopefully they'll have your wallet. Sometimes things go badly and and they don't have your wallet, but hopefully
Okay,
they
so
will.
I would like to see if I can sue about my wallet.
We're not a
That's my
civil,
business.
we're not a civil law firm. We can't advise
Is
you
there
on civil
anybody-
suits.
Yeah, I appreciate it.
Okay.
Y'all can give me some advice.
Mr. Grinnell, you can go to the hospital one time only with a police officer after you're released to inquire about your wallet. If they don't have it, you must leave without any further discussions.
Your Honor, I do understand that. I do understand that. Your Honor.
If they say we don't have it, you turn right around and leave. You don't stand there and argue about it.
Yes, Your Honor.
If you argue about it, the officer is authorized to have you arrested.
I am allowed to go and speak with somebody else about my identification being stripped away from me, Your Honor. at that
As
time.
long as it's not at the hospital.
Exactly.
All right, thank you.
We'll discuss that further. Here's where you have to report.
Is he done?
Yes, he's done.
Thank
Yeah.
Thank you.
Thank you. Good to see you.
Position 14.
14, thank you so much. Miss Adams, that's your client. Did you need to speak with him?
No, Your Honor, we're ready to proceed. It's gonna be a plea.
Okay.
Your Honor, if I may, before we continue, that concludes my business before the court. May I be excused?
Yes, you are. Thank you so much.
Good day.
All right, you too. At jail court iPhone, we have State versus Ray Lynn, case 23 CR 6715Y, accused of public indecency and simple assault from October 25th, 2023. Mr. Lynn, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Samantha Adams. Do you see Miss Adams on the screen?
Yes, Your Honor.
Okay. For purposes of the plea, may I place you under oath? Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Falk, what are the terms, please?
Yes, Your Honor. The terms of the plea are on count 1, 12 months, serve 180 days, credit for time served 16 days. That would be from October 25th of 2023, balance probated, and SDET, 80 hours of community service, no further contact with Leighton Baker, and stay away from all Georgia State University premises and property. We're also requesting an MHET. On count 2, 12 months serve 180 days, credit for time served 16 days. Concurrent with count 1, no further contact with Alyssa Lawler. We did have an opportunity to speak with Miss Baker. She wanted to confirm that she does not know this defendant, does not believe he is a student of GSU. And we would ask the defense to stipulate to venue, factual basis, and identification. I would like to sound from Miss Lawler or Miss Baker if they are here in the courtroom, although I do not see them.
Go ahead.
Miss Alyssa Lawler or Miss Leighton Baker, if you are present, please turn on your camera and let us know if you would like to speak.
All right.
Hearing nothing, we're ready to proceed, Your Honor.
Ms. Adams, do you so stipulate?
Yes, Your Honor, we so stipulate. Thank you.
Mr. Lynn, have you consumed any medication or alcohol recently? If we could please unmute jail court iPhone.
I am on medication. I take Keppel as well as Zyprexa. That's all I'm on is my medication, my prescribed medication. That's it, ma'am.
All right. You don't have to tell us what medication you're taking. That's confidential for you. But all right, understood. And Mr. Lynn, even after consuming the medication, are you still able to understand your lawyer and the proceedings so far?
I'm in complete comprehension of the courts.
Okay, good. And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am. I'm satisfied with my attorney's representation.
If you decide to plead guilty to these charges, you'll be in custody for a significant period of time, after which you'll be on probation. Are you still prepared to move forward with this plea offer freely, willingly, and knowingly?
Yes, ma'am.
Has it been explained to you that if you decide to plead guilty to these charges, they will go on your record?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty, that you will not have the opportunity for a trial in front of a judge or a jury to be able to go into a courtroom with your lawyer to be able to challenge the evidence and the witnesses brought before you, confront your accuser, present any defenses or mitigating factors, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I'm here to give up those rights based off what my attorney has done. Thank you very much.
All right. How do you plead to one count of public indecency and one count of simple assault?
Guilty as charged, ma'am.
Your sentence for the PI charge is 12 months to serve 180 days. Credit for time served, 16 days. You have additional time to serve at the jail, after which you'll be on probation.
Yes,
You
ma'am.
report to probation the first available business day, which can be a Monday, a Tuesday, or a Thursday after you're released from the jail. One, on probation, you will complete a SDET. It is a specific evaluation program that your probation officer will advise you where you need to go. You will also complete an MHET, which is a mental health evaluation, and your probation officer can also identify the programs where you can obtain such evaluations. You must submit yourself to any treatment that is required by both evaluations. You shall stay away from all property that is owned by the Georgia State University complex. You are to have no contact with Leighton Baker and Allison Lawler at all times. You're not to contact these individuals in person, through a phone, through a computer device, or even on social media, and stay 200 yards away from them.
Yes, ma'am.
That concludes your plea, your sentence. Thank you.
Yes, ma'am. Believe the date.
All right. It's 10:45. I still have not heard from Miss McLeod. Jail court iPhone, I'm not certain, but Miss Adams, I'm going to go over your cases right now,
Yes, ma'am.
starting with position number 12.
Yes, ma'am.
Position number 12 is released, 13 same person released, 14 is a plea, 15 Lyons is a plea, 16 is reset Grady to November 16th. Position 17 was a plea, 18 is null cross, 19 Kelly Rabon is released,
Yes, ma'am.
and that's further notice. Position 20 Justin Smith is was it null crossed?
So, Your Honor, the situation.
Oh,
Position
that
20,
person took a plea the other day.
Oh, okay. So
20,
position
2021.
21 and 22.
Your Honor, position
It was
20.
20 and 21.
Yeah, he was null crossed on position 20. On position 21, he took a plea. But on position 22, Your Honor, that's a not guilty plea and a bond modification request.
Okay. Have you filed a waiver of arraignment?
Your Honor, I believe he's already been arraigned on this charge.
Okay. All right. And we'll come back to 22. 23 was a plea. 24, Michael Tuggle is conflict counsel.
Excuse me, Judge Law, this is Milton.
Yes.
I have Attorney McLean on the, Attorney McLeod on the phone, on speaker. Go ahead, Ms. McLeod.
Good morning, Your Honor.
Good morning, Ms. McLeod. How are we doing for cases?
I was calling before Judge Edie on a jury trial calendar, and I'm still here. I have not yet been released by him.
Are you waiting for your case to be called, or are you able to ask the judge?
My case to be called. I do believe it will be called soon, Your Honor, but he hasn't called it yet.
Would you be able to approach the judge and ask for a 10-minute recess?
I'm sorry, I didn't hear that, Your Honor.
Would you be able to approach Judge Edie and ask for a 10-minute excuse?
I will ask, Your Honor.
Okay, if you can, then please get on the Zoom. We still have to do our 11 a.m. calendar, okay?
Yes, Your Honor, I will ask. Thank you, Your Honor.
And then just let Deputy Milton know if that works out. Thank you, Deputy Milton. Okay.
Okay.
So we are position 24, at least on Miss McLeod. So I think that addresses, and on the probation calendar, Miss Adams, I can't recall, I think, position number, we've addressed positions 3, 4, and 5. Position 1 and 2 is Miss McLeod's cases.
Yes, Your Honor.
Did I have a Deneen Walker? There was an add-on. Position 26.
Yeah, Mr. McLean said that was a couple of weeks ago. I did receive an add-on calendar.
Second on the third row.
Okay, that was a few weeks ago, so I'm gonna cancel that. Okay. Mr. McLean, may I go over the calendar with you?
Yes, Your Honor.
All right, position number 1, Abdul Rahman was a plea, and position 8 was a null cross. Position 2 is a case was arraigned and further notice for trial. Position 3, Collins was a plea, and position 4, Collins is a null cross. Position 5, Edwards is a plea. Position 6, Gray was a plea. 7, Grinnell was a plea. 8, attorney null cross. 9, Jean-Louis was a plea, and 10 and 11 is arraigned and further notice for trial. Would that be correct?
I'll take a look at number 11, Your Honor. I believe that is correct.
Yeah, I was on Charity.
That was a bench,
That's her
yeah, that's the
associate.
bench warrant for Charity Jones.
Right, that was the associated FDA guy.
Yeah.
Thank you.
All right, so Mr. Derek Howard available by any chance?
He's coming now. I'm about to let him in, Your Honor.
All right. So Ms. Falk, we can go into a breakout. Is anyone else joining us in the breakout who's present right now?
Your Honor, did the jail have Mr. Smith, position number 22?
Oh, Justin Smith, I think you aren't you entering a not guilty?
Yes, Your Honor. We were also requesting a bond modification.
Oh, you did mention that. Okay. Are you waiving? I don't know where he is. Did you check with Deputy Francois?
Deputy Francois is not in here at the moment. We can waive appearance if he's not here and just go forward.
All right, you need to submit that written waiver as soon as you can to Ms. Grace.
Yes, Your Honor.
All right, and you said this case has already been
Miss Strong, please, Judge. I'm
Oh,
the
Ms. Strong, I'm
manager
sorry.
today. No problem.
Send it to Ms. Strong. So this is 22, one of the cases in which he's not been addressed, right? His other cases have been addressed.
Yes, that's correct, Judge.
Okay.
He may also have a felony pending, Your Honor, but as far as his other 2 misdemeanors that are on the calendar, they have been addressed.
Okay, so the only case I have open right now with Mr. Justin Smith is 23 CR 6726H. He's accused of simple battery from November 27, 2021. Looks like the other case to which he pled was battery family violence from December 15, 2022. All right, so what's going on? And you've waived his appearance. So yes, go ahead.
Yes, Your Honor. We're requesting a bond modification. He originally had a $20,000 bond, but because two of his cases are now disposed of, I believe his bond is somewhere around $13,000. $10,000 of that is for the felony. $3,000, I believe, is what is on the misdemeanor. The state can correct me if I'm wrong about that. But Your Honor, because that is a fairly high bond. He was working at Crystal's before he was arrested, but he's been in jail for 259 days. We're requesting that his bond be lowered to maybe $1,000 or $1,500 on this particular. On this particular charge, Judge. Mr. Smith does have a GED. He has a place to live, and he was gainfully employed prior to being arrested.
All right, so he does, his Superior Court case is still open, is that correct?
Yes, Your Honor.
And he was booked in on February 23rd, 2023 on those Superior Court matters.
Yes, Your Honor.
Okay, so I'm just trying to attribute the time that he's been in jail. It's not because of this case, it's because of his new case from, looks like the offense date is November 25th, 2022. He was booked in on February 23rd, 2023, and he's got a $3,000 cash bond on this current charge.
Yes, Your Honor. The request that we would like to make is if the court is not so inclined to reduce the amount, we would be requesting that at least be converted to a surety bond from a cash bond.
Okay, let's see. Ms. Falk?
Yes, Your Honor. I just want to point out that that case for which the defendant is on hold for is 23 SC 186 7. And let me just pull up my email just popped up while I was looking at the case number 579, and that is for aggravated assault, burglary in the first degree, possession of a firearm by a convicted felon, possession of a firearm during commission of a felony, and criminal trespass for which he's being held on no bond. So that is what's keeping him in. I want to also point out that this defendant since August of last year has had 4 arrests. He's had the arrest for which he pled for in the other courtroom, simple battery, family violence, theft by taking, criminal trespass that involved Miss Jasmine Godfrey on August 30th of 2022. Then he had another case involving Jasmine Godfrey on December 15th, 2022. He then picked up our case, which was November 27th, and misspoke, 2021. So in 1 year we've had so in 2 years, we've had 4 cases, and this incident involves the officer arriving at Camp Creek and Butner Road, speaking to one of the passengers in a traffic accident. The defendant had become irate and stated the other party did not yield when entering the roadway. They made contact with Mr. Keith Hatchell, who stated he was rear-ended by the defendant and had damage to the rear of his vehicle, and that the defendant hit him in the face with a closed fist when they exited the vehicle after the auto accident. So there is a lengthy history here involving a lot of violence, and for that reason, we ask the bond remain as set.
Anything else, Ms. Adams?
Yes, Your Honor. I just wanted to remind the court that one of the cases that the state made has actually been null crossed, and the other one he has taken a plea on it. I think in part because it was a time served plea. I do believe it may have had something to do with the amount of time that he has been in Fulton County's custody.
Understood. The bond modification is denied.
Thank you, Your Honor.
And Your Honor, the state is withdrawing our recommendation on this case.
All right, thank you. Okay, I still don't have Ms. McLeod, and I still need Mr. Derek Howard for competency calendar. So
He's logging on now.
okay. And do we have anyone else who's joining us in the breakout besides Mr. Howard and Ms. Falk?
No one from the state, Your Honor.
Okay. Typically we have Ms. Ball, Keisha joining us. Okay. Ms. Grace, let me know when Mr. Howard's admitted into the Zoom or is in the waiting room.
Okay, Judge, I will. He's not in the waiting room as of yet.
Okay.
So it's just gonna be you, Mr. Howard, Ms. Falk, and normally it's Keisha and the other young lady, but I don't see neither one of them on as of yet.
Okay. All right, Mr. Howard. Good morning.
Good morning, Your Honor.
All right, who do we have accompanying us?
It may be just us, Ms. Burgess we were just getting Ms. Gutierrez transported to Anchor. So she's with the investigator now, taking her to Anchor. So it may just be you being Ms. Falk.
Okay, all right. Miss Grace, if you could place the three of us in a breakout session, please, and let
Will
me
do,
know
Jim.
when Miss McLeod comes on to the.
Will do, because she has cases on as well.
Okay, thank you.
Miss McLeod, they're in a breakout session. I have to get to your clients when they come out of breakout.
Okay, and I apologize. It just, I just couldn't leave.
Good morning, Ms. McLeod.
Good morning.
Remember, I told you about your clients that's on the competency calendar, so I'm gonna add you into the breakout room.
Yes, okay.
Hey, Ms. McLeod, you gonna be able to do conflict today, this afternoon, 2 o'clock?
Yes,
All right, thank you.
yes. Is it possible for me to speak with Mr. Tuggle?
Stand by, let me go to 3 South.
Okay. Hello. I was just finished with Judge Edie. Yes, I'm doing SAP right
Ms.
now.
McLeod.
Yes, ma'am.
Hey, good morning. This is Francois. So just to let you know, you have conflicts here. So I know you're in court now, but I'll just call
I
you.
almost finished with court, but I do have to speak to Mr. Tuggle if he's available.
Okay, because
Position 24.
oh, well, I'm not handling that. I'm
Okay.
doing misdemeanor right now, so that's why I was telling you.
Okay.
But
How many conflicts?
for misdemeanor, it's gonna be, hold on, I'm getting ready to tell you. Let me check. It's gonna be Greer and then also Miss Walker. So it's 2 people.
2 people. Okay.
Yeah, for misdemeanor.
That's fine. Mhm.
Okay. So they're gonna assist you because I'm done with the SAP. So
Oh, they're calling me. They were calling me from the jail just now.
okay.
Let's see.
Okay, Miss McLeod, is she available? Miss Strong, is she in a breakout? Sorry, Miss Grace.
Oh.
Oh, that's
She, okay, there she is.
Yes, Your Honor.
all right.
I was able to speak with Mr. Tuggle.
Okay, and which case are we beginning with? ACDC, Deputy Milton, you have a defendant there. Is she represented by Miss McLeod?
Yes.
And what's her name?
Adrian Robinson.
Yes, Ms.
Okay.
Robinson. Okay.
You need to speak with her?
Oh, I think Miss Robinson will speak to Miss McLeod in a breakout, and we will do that as soon as we have handled Mr. Tuggle. Thank you.
All right, thank you.
Jail court iPhone or courtroom 2? Do we have Michael Tuggle? All right. Did you speak to Michael Tuggle?
I did, Your Honor. I did, Your Honor.
In a breakout?
I spoke to him on the phone. I was just finishing up when you came on.
And do you recall which location you were at? Was that in courtroom 2 or?
He was on the phone. They called me, Your Honor, so I'm not sure where they called from.
Okay.
Hey, Judge Law, Mr. Tuggle's gonna be on 3 South. That's gonna be with Ms. Blunt.
Okay.
There's no clients here for courtroom 2. It's just gonna be done on the floor.
Okay, might see you at 2 o'clock then.
Okay,
Thank you. All right, we're just waiting on 3 South to chime in. While we are waiting, Ms. McLeod, do you want a quick breakout with Ms. Robinson? Just give, oh, here we go. Michael Tuggle. Deputy Milton, is there a phone number that you can put in the chat to Attorney McLeod so she can call she can call your location to speak to Ms. Robinson?
Yes.
All right, go ahead and put that number in the chat. And Ms. McLeod, you can call directly to ACDC after this SAP session's over.
Yes, Your Honor, I will do that.
Thank you. We have a State versus Michael Tuggle. Mr. Tuggle is on the jail court iPhone 23 CR 5920G. Mr. Tuggle is accused of battery from October 3rd, 2023. Mr. Tuggle, I will remind you, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Maureen McLeod. Ms. McLeod, what's your announcement for this case?
Your Honor, my client wants to take the state's plea offer. The only issue is that he's currently homeless. He doesn't have a phone. He doesn't have an email address. I found that out when I was trying to get the information for probation because they're asking him to take some anger management courses. So he's not in a position, he has no contact. And that is the issue. He doesn't have a phone. He doesn't have a place to live. He was hoping he could get on with PAD or something. But of course, I cannot get social worker visits for my clients because I don't work for Fulton County. But he's really in need because he's homeless.
Okay. I'll address a non-negotiated plea if you have a recommended sentence that you are ready to present.
Yes, Your Honor, I would ask that the court.
Oh, no, I'm going to, if you do have, we'll proceed with a non-negotiated plea.
Yes, we would. We would.
Okay. All right. Mr. Tuggle, we're going to do a non-negotiated plea hearing in which the state is going to give me their recommendation as to what your sentence should be. And then your attorney is going to give me an alternative recommendation. Before I accept any plea, I will let you know my decision so you can make a decision with your attorney as to whether you want to plead guilty or not guilty. Ms. Falk, what are the terms of the state's offer?
Yes, Your Honor. The state's recommendation here is 12 months to serve 75 days in jail, credit for time served 38 days. That's from October 3rd, 2023, balance probated, stay away from the Chevron gas station at 336 Joseph E. Lowry Boulevard. No further contact with Isaiah Spearman III and 12 weeks anger management. The basis for our recommendation was an incident that happened at that location where the Officers spoke to Mr. Spearman, who was bleeding, according to the police report, from his whole body. And he stated he was coming out of a store after making a purchase when he was assaulted by two males who took $90 from his possession. When they went and ran the video, they were able to see multiple male subjects standing outside the entrance of the door, the victim coming out, and the defendant throwing the first punch at Mr. Spearman with a closed fist, although they did say it did not appear anything had been stolen. Mr. Tuggle was identified based on that video and arrested. He did have $55 in cash in his possession. I will state that the history of Mr. Tuggle, he has 48 cycles. And they run the gamut. He has starting in his history starts in 1976. And he has been arrested for charges such as aggravated assault, been convicted of dangerous drug charges, has been convicted of possession of a firearm by a convicted felon, has been convicted of simple assault and battery and simple battery that was pled down from aggravated assault. That was in 1995. Another simple battery in 1995, BGCSA in 1997. He had another arrest for aggravated assault and terroristic threats in 2003. He pled guilty in 2004 to possession of drugs and willful obstruction of law enforcement officers. He's had several parole violations, criminal solicitation. He was arrested for family violence, simple battery in 2018. And his most recent arrest was, previous to this, a probation violation in 2023 and a theft by taking in August of 2022. So that was the basis for the state's recommendation as to anger management based on the history of violence in his record. And the fact that this did appear to be an unprovoked attack.
Mm-hmm.
Your Honor, in fact, it was not unprovoked. I distinctly remember from when we were on the first appearance calendar what my client had told me. He said that the reason why he attacked the person that he attacked was because he was going around the neighborhood sexually assaulting women. I remember that distinctly. And I actually went back to check my notes, and that is, in fact,
then the task would be to call the police instead of taking matters.
It was, Your Honor. Okay. His judgment may have not been good, but it was not unprovoked from his standpoint.
Well, that's a debatable issue. What is your recommendation, Ms. McLeod?
I definitely think a time served in this case would be best, Your Honor, because my client is, based on his current circumstances, is not going to be able to successfully complete probation. He doesn't have a phone, he doesn't have a home, he doesn't have an email address, and he's not working. He's 64 years old. So I would just ask the court for a straight time served for him. He's been in jail for almost 40 days already.
Okay. He's been in custody now for 38 days, if I'm not mistaken, the last time I checked.
Yes, Your Honor.
Okay, 38 days. All right. I'm going to accept a recommendation of 12 months to serve 75 days, credit for time served 38 days, balance suspended, and he needs to stay away from the Chevron gas station and have no contact with Isaiah Spearman III. Now, with regards to the jail time, he is not to receive 2-for-1 ratio. He must serve day for day, which means that he would have an additional 37 more days to serve at the Fulton County Jail before he's released and balance suspended. Is that something that your client would like to do?
Yes, Your Honor, but could we also ask if he can get a social worker visit, Your Honor, because he needs help?
All right, you would need to reach out to Mr. Derek Howard, all right, and just request on the procedure to get a social worker to visit him. That would be one of the individuals in that provision. I know Miss Keisha, Miss Burgess normally does or Miss Amin, but I don't know the protocol on how they contact individuals to set up the visit.
Yes, Your Honor.
Okay. Ms. Falk, any comments on the recommendation?
Yes, Your Honor. The only thing I would ask for the court to do is to make that 150 days jail, credit for time served 38. I believe because of how the jail works, there may not be a way to do anything other than the 2-for-1. And so that way it would still equal the same result that Your Honor is searching for, but would not cause any issues with the jail.
Any objection?
No, Your Honor.
All right. Mr. Tuggle?
Yes, ma'am.
All right. I have accepted the recommendation that you are to serve an additional 37 days at the Fulton County Jail.
Yes, ma'am. Your
After
Honor.
which you will not have to be on probation, but you cannot return to the Chevron gas station. You have to stay 200 yards away from that location, and you cannot have any contact with Isaiah Spearman.
Yes, ma'am, Your Honor. I
Okay,
understand.
no matter what happens, you're not to take the law into your own hands and try to correct a wrong. That is not something that you're authorized to do. Are you willing to accept this arrangement?
Yes, ma'am.
All right. Mr. Tuggle, please raise your right hand.
Yes, ma'am.
Do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Ms. Tuggle, have you consumed any medication or alcohol recently?
Yes, ma'am. I'm on drugs, man.
Have you consumed any medication recently?
Have you taken any medication?
Yes, ma'am.
And are you still able to understand what's going on?
Do you understand what they're talking about?
Yes, ma'am. I understand, Your Honor.
Okay. Is there an issue with the audio, Deputy?
I didn't hear you, Judge.
Okay. I guess we'll just keep repeating the questions as long as Mr. Tuggle can understand.
Okay.
Mr. Tuggle, are you satisfied with your attorney?
Yes, ma'am, I am.
Is anyone forcing you to plead guilty to the 1 count of battery against Isaiah Spearman?
Yes.
Who's forcing you to plead guilty?
No, ma'am.
Are you doing so freely and willingly?
Yes, Your Honor.
Are you prepared to give up your right to a trial, to go back to court, confront your accuser, challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery? How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 150 days, credit for time served 38 days, balance suspended, no contact with Isaiah Spearman III, and to stay away from the Chevron gas station at 336 Joseph E. Lowry Boulevard in Atlanta,
Yes,
Georgia.
ma'am.
That's the sentence. Thank you very much.
Thank you, Your Honor.
Your Honor.
All right, then.
Thank you, Deputy. We are concluded with Mr. Tuggle.
I got probation position number 1 and 2.
Thank you.
Mr. Claxton.
Mm-hmm. Officer Allison? Oh, good. She's still with us. Okay.
I'm here.
Thank you. All right. This is State versus Errol Claxton. Mr. Claxton, can you hear me?
Yes, ma'am.
All right. As I indicated, you have a probation revocation case, 23 CR 5870G, and a probation warrant case, 23 PV 1491. You have been advised of your right to remain silent. Your attorney is Ms. Maureen McLeod. And Officer Allison, you still are deemed to be under oath. What's the basis for the revocation?
Mr. Clayton failed to report as directed. He did not complete 4 weeks of anger management and did not appear for a previous revocational hearing on July 19, 2023. He has 40 days remaining on his case. Probation is recommended for time served, case closed.
Right, and this would be Mr. Claxton, right?
Yes.
Okay. Ms. McLeod, any objection to the state's recommendation?
No, Your Honor.
All right. This will be marked as a probation violation. We will accept the he'll be given credit for the time served, and sentence will be commuted to time served. And that concludes his obligations for this case. If he has no other holds, he should be released, and this case is concluded.
Thank you, Your Honor.
All right, thank you. Deputy.
Karen, that concludes probation matters. Can I be excused?
Yes, ma'am. Thank you. All right.
Thank you. Have a good one.
Court is concluded right now. Ms. McLeod, did you get the phone number to reach your client?
I did, Your Honor, and I'm
All
just
right.
going to speak with her.
Okay, great. All right, everyone. I'll be back at 2 o'clock, and other than that, we are concluded. Have a good day. Thank you.
Yeah.
Okay, thank you.